Hello and welcome to this webinar on securing and protecting your child's educational rights. My name is Claudia Hillemand. I'm a partner in Boat Burden Kemp. I represent children who have sustained a brain injury as a result of medical negligence. A part of my work also involves representing children and young people in the Education Appeals Tribunal, which is called the SENDIST. And there I have helped parents appeal refusals to get an education healthcare plan for their child, to help them appeal the contents of the plan that they have got, and also help them appeal the school placement that is named in that plan. So today I want to talk about securing and protecting your child's education rights after a brain injury. I hope to provide some useful information to help you ensure that your child is getting the educational support that they need. And today I wanted therefore to run through the benefits of having an education healthcare plan, the legal definitions of special educational needs and special educational provision, some tips on requesting an education healthcare needs assessment, some tips on the content of a draft plan when you get that, and some tips for dealing with the annual review process. I'm then going to move on and talk about challenging local authority decisions and some key dates to be aware of. And then I'm going to set out some places where you may want to go to for some help and support. I should say that this webinar doesn't deal in detail with school placements, and that is covered in another webinar that I've recorded. So before embarking, I suppose it's worth just saying that the current SEND crisis can't be ignored, and I'm sure it's something that you're aware of. It really can be a battle to get an education and healthcare plan. And when you can get a plan, it can also be a battle to ensure it is a well-written plan. And it can be a further battle to ensure that your child is in a suitable placement with that plan. So I don't say that to put anybody off, but just to present a realistic picture of how difficult it can be. I think we also need to be mindful that there was recently a green paper proposing some changes to the system. This webinar obviously is going to focus on the law as it stands. Those changes are at a very early stage in the process of changing the system, but I guess just keep one eye on the future. And finally, before starting, what I would say is that whilst the current law isn't perfect, if it was actually implemented by local authorities, I do think children, young people and families would be in a much better position than they are, or in my view, than they will be under the new proposed changes. Okay, so starting with an education healthcare plan and what it is. Education healthcare plans were introduced to replace statements of special educational need. An education healthcare plan is a legal document that describes a child or young person's special educational, health and social care needs. It sets out the extra help that will be given to that child or young person to meet those needs, and how that help will support the child and young person to achieve what they want to do in their life. So you'll see a bit of the focus today is on sections B, which sets out special educational needs, section F, which sets out the provision to meet those needs, and section I, which is the placement. And that's because those are all the sections that can be appealed in the tribunal. So what are the benefits of having an education healthcare plan? I've put a few down here. So an education healthcare plan can provide support from birth up to 25 years of age. That's beyond the normal educational range that we tend to think about. It doesn't provide support at uni, but it does up to further education. Special schools or specialist provision within mainstream school are very unlikely to be accessed unless your child has an education healthcare plan. A further benefit is that the named school or college must accept your child if they're named in the education healthcare plan. Places in mainstream schools will usually be allocated first to children with education healthcare plans, and the local authority must fund the placement. Through an education healthcare plan, a child can get access to treatment that they might not be in a position to access privately if that is an educational need. So if it amounts to training or education and the child needs it to access the curriculum, it should be provided and funded by the local authority through an education healthcare plan. This document can also integrate support into school, providing for a more holistic approach. So school is where your child is going to spend most of their time. And so social health and education aspects are brought together and integrated into one document, which can help to provide a more holistic approach to your child's needs. An education healthcare plan is legally binding on the local authority. It requires the local authority to provide the provision in Section F, and that is an absolute duty. If budgets are tight, they still have to prioritise children with education healthcare plans. And so for that reason, having an education healthcare plan can be a good piece of protection to have in your armour. Transport falls outside education healthcare plans, but local authorities do have to provide transport to the named school if your child's over 8 and the school is more than 3 miles away, or if it's more than 2 miles away and your child's under 8. So just very, very lightly going to touch on some legal definitions. What are special educational needs? So special educational needs are learning difficulty or disability which requires special educational provision. A learning difficulty is defined as having significantly greater difficulty in learning than peers, or disability which makes it difficult to use facilities provided in mainstream schools and colleges. Special educational provision is defined as education or training additional to or different from that made generally for others of the same age in mainstream. So there are 4 broad categories of special educational needs: communication and interaction, cognition and learning, social, emotional and mental health, sensory and or physical needs. These appear in Section B of the Education Healthcare Plan. So in my experience, almost all children with a brain condition or injury have special educational needs. And that can be a huge range. Even very subtle aspects of their presentation can amount to special educational needs. So if we take one end of the spectrum is emotional and mental health issues, some of which can be quite subtle. And at the other end of the spectrum, you can have children with significant physical and cognitive needs. Children don't need to have needs in all 4 of these categories to get an educational healthcare plan. And what I would just flag is that there are things that fall under special educational needs that you might not think would be a special educational need. Something like a child who's a school refuser or not sleeping well and there's a decline in behaviour at home, that can be a special educational need. And parents aren't always aware of what it can be, so you might be inclined to think, well, that's just how they are. But it's worth discussing it with the school, doing some research and probing to see if what your child presents with could be defined as a special educational need. So moving on to special educational provision, and what are we talking about here? The special educational provision appears in Section F of the plan. There's obviously a huge range of provision that can appear in Section F of the plan to reflect the huge range of special educational needs that appear and can appear in Section B of the plan. So special educational provision can be things like therapies, occupational therapy, physiotherapy, SALT, speech and language therapy, can extend into hydrotherapy, music therapy, art therapy, rebound therapy. Special education provision can also be equipment, so that can be a wheelchair in school, a K-walker, a sloping board, ear defenders if your child's got noise sensitivity, a laptop, eye gaze, specific speech software. It can also be one-to-one support for a fixed number of hours for certain hours per day and certain days per week. It can be things like breakout areas to address fatigue or sensory overload. So there's a huge range of what special educational provision can be. And that range, as I say, is as big as the range of what special educational needs can be. So it's impossible to list them all, but hopefully that helps give a bit of an overview of what that provision can look like. So if you think your child needs extra support in school and that they have special educational needs, what do you do? So first off, I would say to set up a meeting with the SENCO, get the school's thoughts, share what you have in terms of documentation, share reports, be they medical reports, therapy report, any specialist reports that you have. Discuss with the school if they feel that they can meet your child's needs through their existing budget. It might be appropriate to ask the school to start an individual education plan, and that is a way of keeping your child's progress under review. So you identify what the child is struggling with, you set some short-term goals, you put in place some extra support within the school, and if they don't meet those goals or make progress within the timeframes allocated, you can then go on to request an educational healthcare plan. I would say that this step may not be necessary if your child's needs are quite obvious, and it is case specific, but as a general rule, in my experience, when there's a acquired brain injury, it's appropriate just to press on with requesting an education and health care plan as soon as possible. But as I say, it will be case specific. So if you get to the point where it is appropriate to request an educational healthcare needs assessment, it's important to be aware of the test. So the test is, does or might the child have special educational needs? Might they need special educational provision through a plan? And if the answer to that is yes, then the local authority must carry out an education healthcare needs assessment. So do the schools support it? And you should have had this conversation with the school by now. If yes, they need to write to the local authority SEND team or director. If they don't, you can write to them, but it is preferable to have the school support with these sorts of things. So whoever it is writes to the local authority SEND team or the director, and that needs to contain quite a lot of information, preferably. So I would say you need to list the difficulties that your child has. Attach all relevant information. That might be school reports, therapy reports, expert reports. Maybe you have a diary. Maybe you have video footage of behavioural issues. You probably need to include details of medical history where appropriate. Did your child meet their developmental milestones? What's the family situation? What led to your child having an acquired brain injury? It may be appropriate to set out a before and after picture, so details of their personality, social behaviour, personal development, their independence, their academic ability, their interests, both before and how that has been affected post-injury. If there are difficulties at home and at school, you should set that out. Why do they need extra support? What do you think the consequences will be if they don't get that extra support? Detail why you think an education healthcare plan is needed. What do you think your child's special educational needs are? What provision do you think that they are going to need? Do you think they need therapy to access the curriculum? Do you think they need some specialist teaching? Do you think they need one-to-one support or more small group work? Is there any specialist equipment you think they need? If so, set that out and why. If you're in a position to fund getting some private reports to support this application, I mean, that's great if you can. So that might be from an educational psychologist, it could be from an OT, a physio, a speech and language therapist, and that can be hugely beneficial to have that. It informs this, it really bolsters this initial request, and it will ultimately inform the content of the educational care plan if you get one. I appreciate that isn't always an option financially, and you don't have to have it by any means. It might be that you have some NHS reports that you can use. It might be useful to mention in some NHS therapy appointments about school and that you're a bit concerned, so that they can make some comments in the paperwork that will be available to you through the NHS services. And then that can be provided as part of your application when requesting an EHC needs assessment. A final point when requesting a needs assessment, I would say don't be put off by misinformation. Some examples of such misinformation can be, you have to have an educational psychology report. You don't have to get your own educational psychology report before asking. Nor do you have to show that the school has spent their notional 6K budget on your child. Nor do you have to show that your child is a certain number of years behind. None of those things are necessary before you apply for an education healthcare needs assessment. So you've applied, what happens next? The local authority will decide after 6 weeks if they will do an assessment. If they agree, the local authority will gather information. So they're going to gather information from you as parents, from the child or young person, if appropriate, from the school, from health services, from social services, from educational psychologists, from any therapists, if appropriate, from any visual or hearing impairment teachers, from medical professionals, key people who are involved in your child's life. So they go and do all of that. And then at the 16-week mark, they decide and tell you if they're going to issue a plan or not. And you should get a draft plan if they're going to issue one. You then have 15 days to respond to that draft and to name your preferred school. So you need to have done your research in good time into placements and your preferences if you want your child to move. So you provide those comments and you confirm your placement preference. And then at the 20-week mark, a final plan should be issued naming your child's school. So at this point, the appeal rights are triggered. So you could have appealed the refusal to initially assess if that was refused. You can appeal the refusal to issue a plan at that week 16 mark. And then you can appeal the content of the final plan. And those are stages at which you might want to think about going to an education solicitor. And that's something I'll touch on a little bit more towards the end of the webinar. So I'm going to move on now to tips for an education healthcare plan, the content. So for example, when you get this draft plan, things to look out for. So what's it going to look like? It's going to have all of these sections from A to K. It can be quite a long document. In fact, I would say it should be quite a long document. Section A sets out the views, interests, and aspirations of you and your child. Section B sets out special educational needs. C sets out health needs related to special educational needs. D sets out social care needs related to special educational needs. E sets out outcomes and how the extra help will benefit your child. Section F sets out special educational provision. G sets out health provision. H sets out social care provision. I is the placement. J is personal budget. Now, I'll describe what that is a little bit later on. K is advice and information, and that's basically a list of all the information that was gathered during the educational needs assessment that's gone into creating this plan. I would say can be hugely helpful to get an education consultant or solicitor to look at a draft plan, but I just know that isn't always an option for families. So some charities can assist, and I'll mention them later. But I've highlighted the ones that you really need to focus on, and those are in red, so B, F, and I, because as I mentioned at the beginning of the webinar, those are the sections that trigger an appeal to the SENDist. Okay, so what do you want to look out for when you get this draft education healthcare plan? You want to look out for things like the local authority trying to move education provision into health. So that's things like occupational therapy, physiotherapy, speech and language therapy, equipment, hydrotherapy. Remember in your mind, if it's necessary to access the curriculum, it must be in education in section F, and the local authority must provide it. Moving things into health, section G, means that the NHS provide it. And that means the local authority no longer have a duty to. And that causes problems with enforcing what is in the plan. So sometimes I see things in section F that really belong in section, I see things in section G that really belong in section F. The other thing to look out for is a lack of specificity. So access to hydrotherapy, for example. You want to see a number of sessions, you want to see how long each one is and how often they take place. Each provision should be really specific. It should be, but it often isn't. And you want it to be because you want to be able to pin down the local authority if they're not providing it. So for example, if your plan says access to hydrotherapy and your child's had one 30-minute session in 3 months, they've accessed it. So there's very few places you can go with that if you feel they're not getting enough. The other thing to be aware of is school holidays, that education healthcare plans can extend to after school provision and social school holidays, particularly if your child tends to progress during the school holidays when they cease having this provision, in those cases, there can be an argument that there should be cover during the school holidays. Training is education. So for many children with complex needs and acquired brain injuries, they will need training in their lives. For example, learning independence skills. It could be training on AAC, on equipment, on powered wheelchairs. It can be training for staff. So you might not think it traditionally falls under education or training, but if it is needed for your child to access the curriculum, it should appear in section F of the plan. Okay, moving on. You have the plan. How is it reviewed? So this is the annual review process. Once you have the plan, it's unlikely it's going to remain the same over time. It's an evolving document that should grow and develop with your child. The first review of the plan must be held within 12 months of the plan being finalised, and then within 12 months of the previous review. The annual review is a formal process. The local authority should gather updating evidence before the annual review meeting and circulate it. At the annual review meeting, you should have parents, you should have schools, you should have key individuals there to discuss the education healthcare plan. Then after the meeting, the local authority goes off and reviews the plan, and they must notify the parent of the child or young person of their decision to amend that plan within 4 weeks of the meeting. I would recommend that you be prepared for this meeting. Don't leave it up to the local authority to make lots of investigations as to how adequate the plan is now. If there have been big changes in your child's needs and presentation, these need to be evidenced and the plan needs to be revisited. Again, private reports can be really helpful, or getting letters from treating people who see your child. Again, keeping a diary, talk to the school about any struggles they might be having, what are their views, how are things at home, is video footage appropriate of any behavioural issues at home? Again, our diary is going to be helpful. Show and evidence any changes or new needs that are presented since the last review of the plan. I would also add that the annual review is particularly important before times of transition. So in the years before transition to primary school, in the years before transition into secondary school, and in the years just before leaving secondary school. And I touch more on this in my webinar on school placements. But just for now, I would flag it's a really crucial time of planning for your child's future. The EHCP is going to be the document that should be encapsulating your child's needs. And that is so important that it's accurate before they move on to their next placement. And it's so important it's accurate to inform what their next placement is. If something changes, you don't have to wait until the annual review. You can ask for an earlier review at any time, as long as you have a good reason. And a good reason can be your child's needs have changed, they're no longer accurately described in the plan, or the provision in the plan is no longer meeting the child or young person's needs. Another little piece of information that's just important to keep in mind. The local authorities sometimes try and pass responsibility onto the school. If you have an education healthcare plan and your child is not getting what is in the plan, yes, you should have a conversation with the school. But if they say it's a funding issue, then the local authority needs to be brought into that conversation. Because as we've discussed, if it's in section B or if it's in section F of the plan, it is the local authority's responsibility to deliver that provision. It's not the schools, it's the local authorities. Okay, so where have we got to so far? We have discussed what an education healthcare plan is. We've discussed the benefits of having one. We've gone through requesting an education healthcare needs assessment and what can strengthen that. We've looked at some tips on content if you get a plan and you get the draft to look through. We've talked about annual reviews and what to be aware of in that process. And so next I want to go on to talking about appealing decisions in the tribunal, because at various points in the journey that we've just run through, it can be necessary to challenge the local authority. So what can you appeal? You can appeal a refusal to carry out a needs assessment a refusal to issue a plan following an assessment, a refusal to reassess needs, a refusal to amend a plan following an annual review or a reassessment, a refusal to maintain the plan, and you can appeal the final version of the plan, sections B, F, and I. Sections B, F, and I can be appealed individually or together. I find it's usually together, but not always. Sometimes it's just the placement that is appealed. The tribunal can only make recommendations about health and social care. So those are sections C, D, G, and H. And there is an expectation that they will be followed, but they are just recommendations. So under the current Act, mediation must be considered before most types of cases can be brought to the tribunal. If you don't want to do mediation, you still need to get a certificate to confirm that you received the information about mediation, but that you decided not to pursue it. You don't need a mediation certificate where the appeal is against the school or institution named in the plan. Think carefully about the chance of mediation succeeding. It'll very much depend on what the issues are between you and the local authority. Often, feeling the pressure of time, and you might feel like there's going to be nowhere to go with the local authority and you need to get on with an appeal. You mightn't want to lose time if you've got doubts that the issues are actually capable of being resolved. I would say that sometimes the local authority don't even send a decision maker to the mediation, which is hugely frustrating for families. The other thing to think about is it a level playing field between you and the local authority? I've had situations where the local authority have refused to attend a mediation if I go. And the other thing to think about is a compromise achievable here? Will it be in your child's best interest? So certainly don't rule it out, give it some thought, but weigh it up carefully. In any event, when you get the mediation certificate, either having been through the mediation process or having at least read the information available and then decided not to go through it, that certificate has to be lodged with your appeal in the tribunal. Deadlines strike the fear into the hearts of lawyers everywhere. So I've put them out here in clear terms. The tribunal must receive the appeal within 2 months of the date on the letter from the local authority giving you the decision you want to appeal, or 1 month from the date on the mediation certificate, if later. If you miss this deadline, a tribunal judge may extend the time for making the appeal, but really you just don't want to be in that position. And I'm going to talk about support during appeals if you're going down this road in a little bit. But firstly, before I do that, what does the appeal process look like? It tends to take around 12 weeks from the starting point of lodging the papers with the tribunal. It's an evidence-based tribunal, so you will need evidence to support what you say you want to appear in the plan. Without a professional saying that your child needs it, you're going to be in real difficulty. So what can the outcomes of the tribunal be? You can get appropriate support for your child. You could get a personal budget for your child. And that is when the local authority give you money to pay for what the child needs. So by way of example, a lot of local authorities have a real shortage of therapists, but if your child needs input from an occupational therapist to access the curriculum, costings can be drawn up and the local authority will give you money, and then you can go and find a private occupational therapist to deliver that provision in school. So that can be an outcome. You can ensure that your child is in the correct placement as a result of the appeal if you're successful in challenging that. And then you can get the protection of a legally binding educational healthcare plan that you feel is more accurate and representative of your child's needs if your appeal is successful. I would just say, if you're going down the appeal road, be prepared as early as you can be, because it actually moves quite quickly once you've lodged the papers. After the local authority decision, the tribunal understandably don't like delays because, if your child's not getting the support they need in school, or if they're in the wrong school, that's quite an urgent situation. So things move quickly, so be prepared with your evidence in anticipation of a hearing taking place within about 3 months of lodging the initial papers. So if you want to get some legal support for the appeal, that is possible, of course. There are different options available to you. So legal aid can be available for some people. It can be limited, and legal aid isn't something that my firm offer, but a number of firms do. You can pay for private input from a solicitor. We don't tend to offer no-win, no-fee agreements in my firm for education matters. What we do is that we try and keep costs low by delegating to more junior lawyers to do the work, and they're supervised by more senior lawyers, such as myself, who have a higher hourly rate. So we do that to try and leverage the hours spent and who's doing most of the work to minimize costs. And I'm always happy to provide quotes depending on the work needed if that's something that would be helpful. If your child has a compensation claim, so either ongoing and you have interim payments, or a concluded compensation claim, the compensation they've been given can be used to fund input from an education lawyer. I mean, the benefit of that being that if you secure support in the plan, or if you secure a personal budget, ultimately you can be protecting the pot of compensation much longer term by avoiding paying for private input in school, because the local authority will be providing at least, if not all of what you think your child needs, a portion of it, which will protect the compensation pot. And other firms have social justice funds where you can apply to be considered as an applicant for their social justice funding. So there are also people outside law firms who can help you. I've put up a link to the Boatburn and Kemp website, and we have a number of resources on our website. Some other charities that can assist are IPSI and Contact, and they're just two. There are a number of charities who can offer help. IPSI have model letters which deal with different issues in the various stages of getting an appeal, which you can adapt to the needs of your child. They also have advice telephone lines. Brain injury charities, or charities linked to specific issues that your child may present with, can also offer SEND support. If it's possible, and you can't afford to pay privately for a lawyer, and you can't secure funding otherwise to get a solicitor, but you can afford some limited input, I would recommend going to an education consultant. They can review the draft plan. They can help you with the initial request for an educational needs assessment. They have lower hourly rates generally than lawyers, and they tend to have really good experience of dealing with local authorities and all the steps taken up to an appeal, getting the plan into really good shape. They've got good experience with that, generally speaking. So I would say to reach out to education consultants for some initial support and guidance. If you're appealing, I mean, ideally you'll have legal representation, but I would say it's by no means impossible without legal representation. A lot of parents do it on their own. I mean, some charities actually assist with legal representation, so it's always worth exploring that avenue. But if that's not possible and you can't get an education consultant or a solicitor to assist, do contact charities, but also be reassured that the tribunal will do their best to make the process for those without legal representation as accessible as possible. And I suppose on that note, a final remark would be really like, don't be afraid to push local authorities. I mean, they are strapped now, probably more so than ever, but that's not your problem. The law is very clear on the obligations that they have to meet, and too often local authorities are not meeting those obligations, and they need to be held accountable, and your child needs a remedy if they're not getting the support they need in school, which is always going to be your priority, quite rightly. And you shouldn't have to push things to a tribunal. You really shouldn't, but often you do have to. And if you get to that point, reassuringly, the appeal statistics are very encouraging and show that most challenges are successful. And it can feel like a really long and frustrating journey, and I feel like this brings us back to my initial point at the beginning. At times you'll feel like you want to give up, but I would encourage you to keep the pressure on, because if you're successful, it can really make a huge difference to the support that your child gets in school in the short term, but also in the long term once they have a plan. So do persevere, do draw on all the resources available to you if you are not satisfied that your child's rights are being protected. I've popped my contact details on that last slide. Feel free to contact me. I'll be happy to help if I can. I really hope that that was helpful, and I wish you all the very best if you're embarking on this journey, or those who are already on the journey of securing as much provision as possible through the local authority and the education healthcare needs assessments. Thank you.